So very heartily welcome in the name of Strohal Legal Groups. And my name is Theodor Strohal, for the ones who haven't seen me yet, but I guess most of our participants had some contact with me already. I'm senior partner in Strohal Legal Group and Strohal Legal Consultants, which is our brand name, our office name in the United Arab Emirates. Yeah, the two-day webinar the title is Your Tax Residence, How Can You Avoid of Being Resident in a High-Tax Country? So this is a good question, and it was mainly raised after our recent webinar I held together with our senior partner, senior lawyer, and also managing partner in the UAE, Jakob Kisser. And we were trying to explain and to see the differences in the double taxation agreement between Austria and the UAE, if this protocol from June last year this year will come into effect. But until now, as far as I know, there has not been any ratification of these amendments of the double taxation agreement. But during this webinar, we were also asked to make a follow-up, mainly what is the result, being taxed in a high-tax country, being resident there and have income from other countries. And this is the main task of this webinar. So we go to the first slide, and I want to explain in the first step what is the difference between limited and unlimited tax liability. Most of you should know this, mainly when you're resident in a high-tax country. The unlimited tax liability occurs usually to the tax resident. If you are resident in a high-tax country, most of the high-tax countries have these rules that you are unlimited tax liable. That means all your worldwide income is taxed in the country of your resident. Limited tax liability means that only the income, the sources of income of the very country will be taxed in this country and not the sources of income from other countries. So a limited tax liability has the result that, for instance, let's say Austria, I always take this example because I know about almost 80% of our participants today have some relationship to Austria. So if you are not resident anymore in Austria and you have income in Austria, like from rental income, you have a condominium and rent it out, or you have some business in Austria, still these sources of income will be taxed in Austria. This is the limited tax liability because the other sources of income, when you're not resident anymore, will not be taxed in Austria. But usually it says residence means unlimited tax liability, non-resident means limited tax liability. This is not all true, because you can also be not a resident in Austria and still have so-called unlimited tax liability. Your worldwide income is taxed in Austria. Why is that so? That you fulfill one of the criteria which do not make you a resident as such, because your domicile is out of Austria. But for instance, and I will come in one of the next slides to it, you are using your Austrian habitat, your Austrian apartment or house more than 60 days a year. Then you become automatically unlimited tax liable with your worldwide income. How can you avoid this? I will show you. And also double taxation agreements will be stronger than the local tax laws of unlimited tax liability, and I will come to these questions further on. So not necessarily limited liability occurs when you are not resident anymore. You can be not resident and still apply even for unlimited tax liability, which has the advantage, I explained this in other webinars, that for instance, you have a deduction from your income of 9,000 euro per year. If you're limited liable, you only have a deduction from your taxable income of 2,000 per year. And other advantages are, for instance, when you're seriously sick, you have an extra deduction from your income. When you have kids, you have extra deduction from your income. And all these tax advantages you only can realize when you are unlimited tax liable. So I know from some clients, even though they are not resident in Austria, they apply for unlimited tax liability to have these advantages. So we go to the next slide. The next slide, just a moment, it's not so easy on my screen. Personal or unlimited tax liability. What are the conditions? What are the criteria for that? First of all, it is, of course, the residence in Austria. So in most other high-tax countries, also the resident is the most important criteria. Yeah. Then the next one would be a domicile. Domicile does not mean that you are not resident, you don't have an apartment there, or you have not a house where you live. You have, for instance, in 2 countries, domiciles or residences. And then it is very important to find out where is the vital interest. Then, of course, the management of your company. If you are living in the UAE, but you have an Austrian GmbH, a limited liability company, you are the manager there and you hold the meetings in Austria, then it could be that because of this condition, you will be resident in Austria, unlimited tax liable. Habitat residences, I will come to on the next page. Very interesting, or maybe one of the most important points, is the center of vital interests. So we come to the next page. What can you do if you are already resident in a foreign country? Let's keep the UAE as an example. And you still have your apartment, your house in Austria, and you have the power to enter it whenever you want. You have the key to this house. What does it mean? If we compare it with Germany, we Austrians have a very important advantage. Just holding the key of a residence does not mean yet that you are unlimited tax liable or resident in Austria. You are actually allowed to have such a second residence in Austria, even if it's empty, if nobody uses it beside yourself. But now, how can you use it? And here is the so-called Zweitwohnsitzverordnung, the second resident regulation, which means that you are allowed actually to use this second resident in your high-tax home country in Austria, it's an Austrian law, for not more than 70 days per calendar year. But also the use by your spouse will count for the 70 days. So when you're together there with your spouse, then it is just 1 day by 1 day. But if you use it for 60 days, and then your wife or husband comes over and uses it for another 20 days, then the 70 days are exceeded which means unlimited tax liability. Very important in this case is that you have to make a recording. You have to have a bookkeeping on the very days you are using this second residence. And also, if you have more than one second residence, of course, this will be added. So maybe you have a holiday home on one of the beautiful lakes in the Salzkammergut, and you have a town house or a apartment in Vienna, then altogether you're not allowed to use both together more than 70 days per year. The usual question is then, I heard from our participants and clients, yes, I use it 70 days a year, but then I move to a hotel. Does the hotel also count? No. This Zweitwohnsitzverordnung, the second residence regulation, aims at a residence, a habitat, a home of the taxpayer. So a hotel would not count. Furthermore, when you leave the country, let's say you spend one weekend in Budapest or in Prague, or you go to Italy for holidays, these days do not count. So you have to record in your writings and have it anytime handy for the examination by the tax authorities. And when you enter, or which day you come and use your second residence, and which day you're leaving your second residence. So also when you stay, let's say, 60 days in your second residence, and then you move to Salzburg and live in a hotel, or you move for holidays to Italy, these days would not count. But always be aware that you do not fulfill other criteria that make you fully or unlimited taxable. But here the second residence is an Austrian advantage and gives you the possibility to keep a home. Of course, you can also rent it out, or you can give it to family members during the time you're not there. This does not matter, but you also can leave it empty. There is no necessity to earn money on it or to give it away. Yeah, as long as you're not using it more than these famous 70 days. As far as I know, the UK tax law, there you have, I think, 90 days per year you can use your home without being fully and unlimited taxable. Okay, we go to the next topic. So if you are in a partnership, in a permanent partnership, or in a registered partnership, or in a marriage, then actually your spouse counts as well as the taxpayer himself. Not only for the second residence and 70 days, but...
Im Webinar, ich weiß nicht, wie lange das dauert, ist extrem wichtig über die Steuer.
Excuse me, may I ask you to mute your microphone?
Okay, put it down. Okay, tschüss.
So very important is that actually every action, every time your spouse or your wife, husband, or also your partner in a registered partnership, we're very open-minded in this case, also partners use your second residence or live in Austria, you are immediately, from the moment on, they take their home there, you are unlimited tax liable. You are resident, even though you live and work and everything outside Austria in the UAE, you have your company there, you're managing your company, but your wife decides, no, I don't want to follow you. I want to stay in Austria. I have my kids here, or my business here, or my parents here. You are unlimited tax liable. So wherever your partner is, this also makes you tax liable. So please try to convince your partner to follow you if you give up your residency in a high tax country. Or alternatively, here in this slide, separation, from the partner. This is one of the most difficult ways to prove towards the tax authorities that you don't want to be unlimited tax liable. When your partner stays in Austria and you are working somewhere else, there are many, many evidences you have to provide to make the tax office believe that there is really a separation. I was always asked, are you keen or are you able to make a separation agreement? I said, no problem, I can make the agreement, but the agreement itself is absolutely not sufficient. There are several and very interesting decisions from the financial court in Feldkirch in Vorarlberg, obviously Austria and Switzerland, or Austria and Liechtenstein, where one of the partners stayed in Austria and the other partner lived in Switzerland or Liechtenstein, where the taxes are significantly lower than Austria. And then they said, we are separated, and the law that the domicile of the partner also creates unlimited tax liability does not apply. And then, of course, the local tax authority denied this fact, and then it went up in appeal to the Finanzgerichtshof, to the financial court, to the tax court in Feldkirch, and they issued 2 or 3 very interesting awards. And one of them say, it's quite an interesting case. They were really separated and they had a separation agreement and everything. But last year, the court says they spent 1 week holidays together in Italy. And spending 1 week holidays with your spouse means you are not fully separated. So if you really aim to this exception, and you want to apply or you want to argue towards the tax authority, we are fully separated and it does not apply when my partner still lives in Austria, I'm not Austrian resident, then please really do the separation 110%, because the tax authorities will really try to turn it around. And actually everything that goes beyond the borders, so-called criteria outside of Austria, has to be proven by the taxpayer. So you are the one who has to bring the evidence that you are really separated. And when the tax authority finds out that you meet your partner regularly, when you have kids and the kids stay with the second partner and you still visit the kids, then also probably the separation will not work out. So this is a very difficult chapter, and most of the awards, most of the decisions we have found are against the taxpayer, that the separation was not acknowledged by the tax authority. I also cited section 156 of the German Civil Code, where it reads very decisively and very well argued what is a separation. Okay, so we go to the next point. What is the center of vital interest? As I told you, there are several levels how to become a tax resident or how to avoid to become a tax resident. First is the domicile. The second is the habitat when you have it in 2 countries. And finally, the center of vital interest is one of the most dangerous proofs you have to bring towards the tax authorities to avoid being unlimited tax liable in your country. Here you have many examples. What is the center of vital interest? I just want to, I don't want to read it out to you. You can do this by yourself. I just point out some of the most important ones. One is your social surrounding. Where are your friends? Where do you spend your free time? That you work in another country is not sufficient. If you regularly come home, or your group of friends are mostly at home and not in the country where you work or where you want to be resident, then this is already one criteria. But this is not enough. Of course, family is the most important part, where your kids go to school. This should be the center of your vital interest. So when you leave your kids at home because schooling is better or cheaper than in other countries, then you can already count that you will not lose your high-tax residence in your home country. But it goes further. It also says there are criteria in the person itself, not only when you watch the taxpayer from outside, where do you spend your time? No, what is in your own mind? And this is also a very, very important argument from the tax authorities' side. For instance, you are a member of some clubs in your home country, which you are visiting regularly. You have a collection of, let's say, classical cars, and you have them based at home in your high-taxed home country, and you take part in these races once or twice a year. This is some personal relationship to your old home country, which can make you unlimited taxable. Yeah, so this is a center of vital interest. So not only family and where you spend your time, and not only your friends, which is an important part, but also other criteria, which I also then listed up in the next slide. The center of vital interests and further criteria. Yeah, if you're a member of a association breeding canary birds, I know it's funny, but the Canary Züchterverein is something very typical for people to engage themselves. Either it's canary birds, or if it's a dog club or whatever, and you are a member of these clubs in your high-tax home country, then be aware this could be one of the arguments of the tax authorities, that you are unlimited tax liable, that your center of vital interest is still in Austria or Germany or in a high-tax country. Yeah, this is not easy to look through, because of course everybody who is leaving a high-tax country, besides when you're a child, but if you're an adult and you get a good job somewhere and you try to avoid now the high taxes at home, you still have strong relationships to your old home country. You have your friends, you're playing cards with them, you're meeting them, you are still a member of clubs and so on. Or you have your collection of whatever at home, like not only cars, it can be something else. And you still have it there, and you don't bring it with you. So also this is a relationship which can finally lead to this fully taxation. We go to the next slide. So now we come to the point when you want to leave your expensive and high-taxed home country. Which kind of proof of residence you have to provide? There are several. Number one, oops, I lost this slide. Let's see where we are. So not only the stay permit you have, or the resident permit, but you need a couple of more proofs besides your work permit. You have to have a utility bill that shows your name. You have a lease contract, and it must be stamped by the authorities. You should have a bank account, and the bank account should show your address in the foreign country. Yeah, all these are criteria to become a resident of a foreign country. Then, if you finally live there 183 days, then you can apply within 1 year. It doesn't have to be the calendar year. Then you can apply at the local tax authorities, like in the UAE, the Ministry of Finance. Yeah, you can apply for issuing a tax resident certificate. And if you can prove that you stayed more than 183 days, or at least 183 days in the country, they will issue it for you. So you have a tax resident certificate. But please be aware, this certificate is no full proof. This is no full evidence to avoid the tax in your home country. The Austrian or the high tax country tax authorities will say, it's nice that you bring that, but now we will check immediately, where is the center of your vital interest? How often do you come to Austria? Do you have another habitat, another apartment, a house in Austria? How long do you use it? How often do you come here? So the tax resident certificate is a good thing, for instance, to claim back, for instance, the Kapitalertragssteuer, capital gains tax from securities. You need the tax resident certificate, but it is no full proof that you're finally not taxable, only limited taxable in Austria. So this is one of the first steps. If you have a second residence, and even if you are not yet limited liable, then there are several advantages. I already explained this in another webinar. You can do business in the country of the second residence. Yeah, it does not mean you have to give up your tax residence or your unlimited tax liability in your home country. You still can have a second residence, so you can do business there. You can open bank accounts, and you can give the bank the address of your second residence, which means under the common reporting standard, the bank will probably not report to your high tax home country, but they will report to the tax authorities in the country of your second residence. Yeah, you can, of course, save on taxes. It depends on the double taxation treaties. For instance, when you earn like wages and salaries in your second residence country, and you're still resident in Austria, in most of the DTAs, double taxation agreements, income from wages, from salaries are taxed in the place, in the country where you do your work. So this would be another advantage. And finally, also, there could be cheaper or better schooling in another country, and you can buy and sell properties in the country of your second residence, and you even can obtain a local driving license, which can be an advantage. So it means you're not yet finally lost your high tax residence in a European country, but you have a second residence, you still have a lot of advantages. You can use it, but here you of course have to go into the details of the double taxation treaties. So how to obtain such a second residence? The participants who are living in the UAE know this very well, but I listed it up here. The conditions to obtain such a second residence, for instance, in the UAE. You can, number one, establish a business. It doesn't matter, sole proprietorship now very popular. Yeah, you can freelancer, or you can do some kind of services like IT as a sole proprietor. Then, of course, you can set up a company, and you are the shareholder in the company, either free zone or mainland. Offshore does not give you the advantages, yeah, mainly from the tax side. Then, of course, you can buy properties. Usually it's 1 million you have to invest in a property, and for the golden visa it's 10 million. Then you get your residency in the UAE. As long as you hold these properties, when you sell them, of course, then your visa would be cancelled. Then you can be employed. Yeah, when you have a employer who has a permanent establishment in the United Arab Emirates, then of course you have the advantage that this income is taxed for the time being still only in the UAE. And then finally, you of course can, besides buying and selling properties, Ras Al Khaimah has, or had, I think they're still on, if you only invest 400,000 AED and one of your family members is still living, has a resident permit in the UAE, then with the investment of 400,000, you could also get a resident permit and live in the UAE. These permits are usually issued for 3 years. Besides, the golden visa is issued for 10 years. So this is how you get the second residency in the UAE. And now we come to the double taxation. Please be aware, number one, a double taxation agreement is only important for you if you are still resident in the high tax country, or in another country than you, for instance, live or work or get your income. So if you already left your high tax country, you really changed your residence, and you are in the UAE and you are fulfilling all the criteria I mentioned before, like center of vital interest, no housing besides the 70 days and so on, then the DTA does not apply for you. It's not interesting. But if you're still resident in the high tax country, then please look at the DTAs. What is the main point? Before you go to the various sources of income, please go all the way to the back, usually around Article 23, 24, you find the ways how to avoid the double taxation. And there it is said it's either the credit method or you have the method of exemption. The credit method means that the taxes you pay in the other country will be deducted from your tax liabilities in your high taxed home countries, yeah, with some exceptions, of course. And if it's an exemption method, it means if your country where you have your sources of income has the right of taxation on this income, then your home country will exempt this income from taxation. So you will pay zero. At the moment, the DTA between Austria and the UAE provides us exemption method for most of the sources of income, you are exempt in Austria. Some exceptions like dividends are always to be taxed in the country of residence of the one who receives the dividends, of the shareholder, for instance. But your wages will not be taxed in Austria. Your income from sole proprietorships, from businesses will not be taxed in Austria. Your income from rent, if you have a apartment or a house in the UAE and the tenant pays you rent, will not be taxed in Austria. So because of this very advantageable double taxation agreement between Austria and the UAE, you can, for the time being, let's see when and if it will change, probably it will, but when is the question. For the time being, you are on a safe haven, doing or having income in the UAE. Not for dividends, please, and there are other exceptions too, but I don't want to go into the details of this. We go to the next slide, and here I listed up some of the DTAs which can be of advantage if you are still resident in Austria. And besides the UAE, of course, there are other countries. The DTA Austria uses the credit, does not use the exemption method, and rather than the credit method. And we have some other countries which are almost as advantageable as the UAE, for instance, the Kingdom of Saudi Arabia and Kuwait regarding wages, but other sources of income have the credit and not the exemption method. Then in Bahrain, this is a very strange DTA. I haven't seen another one, using the exemption method only for business profits. So for instance, wages you earn in Bahrain, it's the credit method. It means the taxes you pay in Bahrain will be deducted from your Austrian taxes. But if you make business in Bahrain, there is exemption. So what you earn from businesses in Bahrain will not be taxed in Austria. Singapore has wages, the exemption method, and some other sources of income, not dividends. And same Indonesia, wages are only taxed in the country where you work and not in Austria. In Thailand, it's a very wide exemption method, similar to the UAE, and wages and most of the other sources of income are not taxed in Austria. It's an old DTA, so let's see if Austria continues to make efforts to change the old DTAs and change the exemption method to credit methods. But I think UAE was a main aim, a main task of the Ministry of Finance. I don't think it will be so easy to change the others. So we also have some favorable DTAs with the UAE. So let's say Austria changes and you have the credit method instead of the exemption, then you can look, where shall I take my residence now? And I continue my work in the UAE, and I still don't want to pay tax in a high tax country. Switzerland is one example. They still have the exemption method for wages and most other sources of income. Then Bulgaria has exemption method actually for all sources of income. So when you become a resident in Bulgaria and you work in the UAE, then you have no problems with Bulgarian taxes. Similar, Hungary, exemption method in almost all sources of income. So our neighboring country, Hungary, has a very favorable, very advantageable double taxation treaty with the UAE. And Thailand is similar, also exemption on all sources of income, besides royalties and dividends. Thank you. So, I have to look for the next slide. So I made you now a slide for an example, and I have to admit, if you read it carefully, that it is somebody you maybe know who did exactly this and avoid taxes very successfully. Take residence in Thailand, which means you get a retirement visa when you're 50 plus. The law will change. It will be 45, and I even heard 40 years of age would be sufficient to obtain a retirement visa. But if you don't get a retirement visa, there are still many other ways for becoming resident in Thailand. Employment passes and many more. Investors. So it is similar to the UAE. It is not difficult to obtain a resident in Thailand. And then you have income, business profits from a country where Thailand has a good double taxation agreement, let's say from the UAE. That means whatever you earn in the UAE, it will not be taxed in Thailand. Thailand actually has a world taxation system, but they have a lot of exceptions. So also, for instance, your pension, which is paid to a Thai account, will be soon free of tax. Now it is taxed, I think, with 20%. But for instance, if your pension is paid to an Austrian account or to a UAE account, and then you send the money yourself into Thailand, this will not be considered to be pension income, but this will be considered as costs of living you are sending over, and costs of living are not taxable. So let's say you're resident in Thailand, your income comes from another country which has low taxes or zero taxes like the UAE, and there is a good DTA between Thailand and the UAE, then you can earn your money more or less tax-free. If you still have good connections to your old home country like Austria, then you can have an apartment there which you use for 70 days per year, or you use it for longer, and then you will be officially unlimited tax liable, but it will not change anything, any disadvantage for the time being, because you are resident in Thailand. And so only the DTA between Thailand and the UAE applies, and not the DTA between UAE and Austria. So be careful. As soon as the DTA Austria UAE will change, then also this argument will have to be reconsidered. So better stay with your 70 days, then actually nothing can happen. And we come to the final slide now. This is a kind of checklist. Yeah, what do you have to consider when you decide to leave your high-tax home country? First of all, look into the country of your new residence. How easy can you obtain your new residence? Is there a taxation worldwide income or only local income. For instance, Singapore has the advantage, and also other countries have the advantage that they only tax local income. So income you earn within the country and not income you earn in other countries. Yeah, so this is a very important argument to set foot in such a country with not worldwide taxation, worldwide income taxation. Then, of course, you look at the DTA. Is there a DTA between your new country of residence and the country where you earn your money? Yeah, if it's not the same country, of course. Yeah, if it's the same country, there is no necessity. But like I explained before, resident in Thailand, income in the UAE, very good DTA. Thailand does not tax it. And is there still a habitat? Do you still have a home in your old high-tax country? If yes, do you want to use it or do you rent it out? I want to use it, then take care of the 70-day rule. Yeah, and you find out how many days per year do you want to spend in your old home country. Actually, up to 6 months per year, you can live outside of your new residence, or you can even stay in Austria, but without using your own habitat, if the center of your vital interest is in your new residence. Yeah, but this is a very, let's say, dangerous argument. Officially, it is the 183 days. But of course, when you really live 6 months per year in Austria, the center of your vital interest will be very hard to deny that it is in Austria. So if you live 2 months, 3 months per year, yeah, you still have the argument, I have my kids in my new residence, my wife is there, or my husband works there. So, but if you come close to the 6 months, then please take care. This will be hard to argue towards the tax authorities. And then check the DTAs, of course, between your old home country and your new country of residence and the country of your work to make it safe. I think this was the main points I had to communicate today, and I thank you for listening, and I'm of course here to answer your questions.